Hello, everybody. Welcome to Ask Concussion Doc. Today, I have a special guest, buddy of mine, and an employment lawyer. Today, we're going to be talking about employment law with respect to concussion, knowing your rights. This has been a highly requested topic from people in the past, and so I'm happy to be able to bring you this topic. My guest today is Luis Quail, who's a founding partner of Quail Warfe Kreder LLP, practices personal injury law, disability, and employment law in Ontario, Canada. He began his career as a prominent insurance defense firm in Toronto, representing insurance companies in personal injury disputes. In 2015, transitioned to representing plaintiffs at a personal injury and employment firm in downtown Toronto. Luis helped that firm grow from having one location and 3 lawyers in 2015 to 3 locations and 17 lawyers when he left in 2021. He represents clients with an emphasis on educating them to make the best decisions possible for their specific needs. You can find him at L Quail, that's Quail at QWKlawyers.com. 416-795-0683 is the phone number. That again is 416-795-0683. I'll do this at the end as well. And their website is QWKlawyers.com. Luis, what's up,
Awesome.
buddy?
Thank you. Not much. How are you?
I'm good.
Yeah,
Okay,
thanks for having me on. I know we've been talking about it for a while, and I know you've been doing this podcast for a while, and I think it's just a good opportunity to reach out to some of your audience, who I know is a variety of clinic owners and people who have had concussions or other injuries. So I'm excited to provide some additional information about the law and what the rights might be, both as in those situations, in those circumstances, as clinic owners, as clinicians, and as people who may be suffering from various symptoms. So thanks.
Right. So just as a caveat before we get going, I just want to point out that you are located in Ontario, and so there may be some jurisdictional differences. And we know that. So if you're in the States, you're going to want to check with a lawyer in your area. But many of these things will be somewhat similar jurisdiction to jurisdiction. So it's just important to make sure you check with somebody in your area to make sure what's best for you. So I just want to keep that caveat before we get started. And so Luis practices in Ontario. So most of the stuff will be kind of indicative of Ontario law. So
and just if I could add also on top of that, this isn't official legal advice. Especially if you are outside of Ontario, like Cam said, the law varies. So if you do find yourself in one of these situations, you should consult with a lawyer and get official legal advice from a lawyer in that area. But I think generally in this area, it's similar across jurisdictions, but it's not all the same.
Right on. Okay, let's dive into it. So I'm going to kind of like hit you with one like right off the bat that I think is a little bit of a contentious issue, but people with acute concussion symptoms, and I've had this before from patients where they are unable to work, they have these symptoms, it's tough for them to work, they have headaches, they have dizziness, they have all these other issues, and they're off of work, and their employer is basically saying, like, if you can't work, like, we're going to have to let you go, or threatening with some sort of basically like termination. Is that okay? Like, can they do that? Like, what are your rights in that situation?
Yeah. Okay. So, I mean, I guess it's a big question. Again, just speaking to the law in Ontario, everyone is free. They're protected from discrimination on various grounds. And that protection extends to discrimination in the workplace. In Ontario, we have a human rights code, and it identifies various groups that are protected from discrimination. And those groups, those listed groups include things like, discrimination based on age, gender, sexuality, ethnic origin, color of your skin, but also disability. So disability, and specifically concussion, people suffering from concussion, those people are protected from being discriminated against in the workplace because of their concussion or disability. And just backing up, what is discrimination, I guess, is the most basic thing. So discrimination is the treatment of someone based on a characteristic that puts them to a detriment to other members of society because of that characteristic. So it's treating someone differently because of their disability that would put them to a detriment to other opportunities that people without a disability might have available to them. So if someone is injured or has a concussion and they're really struggling to get back on their feet, and their employer is telling them to come back to work, they don't necessarily have to do that if they can establish that, or if there's support that because of their disability they cannot do the tasks of their employment. If the employer forced them to do all the tasks of their employment in the face of this evidence that they have a disability, then that employer could face a claim against them for discrimination, because they're forcing them to return to employment when they can't. When an employer becomes aware of an employee's inability to do their job because of disability, it triggers a certain duty, and they have a duty to accommodate that employee. If the employee is having concussion symptoms and says, look, boss, I can't return to my desk job because I can't stare at a screen for 5 hours a day, that employer has an obligation to try to accommodate that disability. And if they fail to do that, that's discrimination on a ground of disability, if that makes sense.
Yeah, it does. And this happens all the time. Like, this happens all the time. I've had this with patients all the time. And even the ones that may not be necessarily facing termination, but just, trying to get back, or they can't sit in front of a screen. Like, at what point does this become discrimination versus like, look, man, they can't do the job?
Yeah. So I guess they are protected as having a disability, and that's where discrimination comes into play. If someone's having concussion symptoms, they have a disability, they need to notify their employer, and then their employer has a duty to accommodate that disability. And that's kind of the way it works. And then the question is, what constitutes reasonable accommodation, and how far does that accommodation have to go? The duty on the employer to accommodate is not an absolute one, and it's not an infinite one. It is limited, and that limit is they have to accommodate the employee to the point of suffering undue hardship to their business. So again, if you look at the staring at a screen example, if you have a concussion, you can't stare at a screen for a certain amount of time. Let's say your job requires you to stare at a screen for 5 hours, but you can only stare at a screen for 3 hours. If the employer can accommodate that, and you can still fulfill your duties by staring at a screen for 3 hours instead of 5, whether it be by taking breaks, or doing a different role for a bit, or having someone else cover you for a bit, and that accommodation does not cause them to suffer undue hardship, meaning, and there's different factors to consider for undue hardship, but like, it doesn't cause them to go out of business or lose millions and millions and millions of dollars, or put others' safety at jeopardy, then that employer has to make those accommodations and has to allow the employee to reduce the screen time, or whatever the case might be.
Right. And what type of documentation would you need in order to get these accommodations? Like, do these accommodations have to be, suggested by, let's say, a neurologist or something, or can it be just what the patient determines they want, or does this have to have some sort of medical, determination as to what these accommodations are?
So I would say if you are in a situation where you're injured and you're having difficulty performing your task, it creates a tension between you and your employer, right? You're unable to fulfill your employment obligations that are required, and your employer wants you to do that. So there's a possibility of getting into some sort of legal dispute right from the outset. So I would recommend that, people are going to a doctor or their treatment provider and mentioning the issues that they're having. It's not enough for them to just tell their employer, look, I can't stare at a screen because I got headaches. There needs to be some substance to that claim. And the substance is, a doctor's note or a note from your treating practitioner. And if it's reasonable, and then that's when it triggers the employer's duty to, investigate it, ask for any further information that they might need, and then look to the workplace to see how they can accommodate that. But it's typically not enough for the employee to just say, look, I have a headache. A headache's an invisible thing, right?
Mm-hmm.
Or like actually most concussion symptoms are invisible things, if not all of them, which is why concussions specifically are so tricky. But that's why when people do sustain a concussion and there is this potential conflict that might happen with their employer, it's very important that they're going to medical practitioners who will then document those complaints.
And let's say, like, I'm just wondering about these accommodations and how far these extend. And I mean, obviously it's a case-by-case basis, so you can't necessarily tell me specifically, what may and may not fly. But, let's say you use the screen example, and this person's supposed to be working 8 hours a day. They can only tolerate 3. And there's like, you're working in an office setting. There's no other jobs that don't involve a screen. Like, how far, are you able to take it? Like, is this just come to the point where, look, you just can't work, you're on disability? Or what does this apply even to return to work? Because a lot of times we try to get patients back into the workforce, and we recommend, look, they need to start with like 1 hour a day, 3 days a week. And oftentimes employers will say, look, I can't do that. And, I think that's reasonable. Like, what would you say to that?
Yeah. So I think that all comes down to the point of undue hardship, right? Like you're asking the employer to accommodate by allowing the employee to come back, a couple hours a day, 3 days per week, or whatever it might be. And if the employer is saying no, well, then the question is, would they be able to, would making that accommodation cause them to suffer undue hardship? And there's different factors that you look at when considering the point of undue hardship. And those factors are the safety of those involved in the accommodation. So if an accommodation request creates a safety risk for that employee or other employees, that's a consideration to make, whether you've reached the point of undue hardship with that accommodation request. Financial cost of making that accommodation. So, let's say someone has a back injury and they need a special chair that costs $5 million, and that's the only chair, and it can't be accommodated any other way. Then that would be something that might reach the point of undue hardship if the employer has to take on that financial burden, and that would cause them some issues. Other considerations are the interchangeability of the workforce or facilities. So if it's as easy as saying, okay, you don't have to do this job out in the field, but we have an office that you can sit in the office and do that job. Mm-hmm. And then also the morale of other employees. So if the accommodation is going to cause, widespread, disappointment among employees and really affect the morale, that's another factor to consider when the courts are taking a look at, okay, should the employer have accommodated, or was it reasonable for them to turn down that request to only work a couple hours per week? Does that make sense?
Mm-hmm. Mm-hmm. There's a question.
So and again, like you said, it's a case by case. Every case is specific. It's all case by case, and it's all very factor. It's specific to the factors of each case.
Right. Someone in the chat here asked, can an employer request a particular frequency of reevaluation?
I think as long as it's reasonable, then that should be fine. And I should say that it's not the employer who's doing the evaluation. It's more that the employee is providing evidence to support the fact that they're having the concussion symptoms of the disability. And as long an employer can ask for, can we get an updated doctor's note or an update on your status, as long as it's reasonable. If it's every other day, and keeping the pressure on, and they're really, acting unreasonable, then, push comes to shove and they fire someone because they haven't provided a new doctor's note within 3 days, then that's something that court would look at and say, okay, they're being unreasonable here. But if it's every couple months or few months where they ask for an update, I think that's generally fine.
What about pay reduction? So let's say that the accommodation you need is you can only work 2 hours a day to start, and they're like, well, we're only going to pay you for 2 hours a day. Is that legit? Or is that I guess it depends on your pay structure or what your contract says.
Yeah, it depends on a lot of things. It also depends on whether the employment has available to them short-term or long-term disability, which is a whole other thing. But if the employees reduced work, they're getting paid less because they're working less, then some employers have benefits available to them through short-term or long-term disability benefits that would supplement that difference. But again, it comes down to the undue hardship. Some disabilities, a lot of disabilities and a lot of concussions, there is no accommodation. And the accommodation is you got to allow the employee to stay home. They can't come into work. And then the employer has to hire someone else and to fill the role. And that happens all the time. I have lots of clients in those situations. If they've been injured in an accident or whatever the case might be, they can't return to work. And then it's can the employer withstand them not showing up to work? And oftentimes they can, if it's a big enough employer. And yeah, that's an accommodation that can be made in a lot of cases, but it has to be supported by some medical evidence or a doctor's note or whatever the case might be.
Can an accommodation be to give somebody a lesser role? For example, so I had a patient, this is maybe a couple of years ago now, but he worked kind of on a factory supply line, and he had just got a promotion. So he was on the line, doing kind of quality control assessment stuff on the line, making sure that, products were going through properly and discarding, flawed products and things. And then he got bumped up to a manager role, which he was kind of at the switchboard, controlling all the different lines and had a bunch of different computer screens and was monitoring a whole bunch of processes. And he had just done his training for that, and he hadn't actually really dug into that role. Gets a concussion. He's off for 6 months. And now when he's trying to go back, he's completely out of touch with everything that he had learned during his training. And he's never actually done that role. But the employer wouldn't let him return to his old job to basically work his way back up. It was basically no, this is your job and you can't come back until you're able to do this job. But even at that, I mean, it's apparently a difficult job for anybody to do and requires some onboard training, which they'd already given him. So, this is just a one-off case for you, but
yeah. So, I mean, there's lots of different legal topics that are being touched on in that specific case. But I would say there is a concept in Ontario anyway of constructive dismissal, and that's where typically an employer has basically unilaterally changed the terms or the fundamental or a fundamental term of the employment relationship to a point where they made a substantial change to a fundamental term of the relationship. And the fundamental terms of the relationship include things like duties and compensation and hours of work and things like that. So if an employer tries to say, okay, we're going to change your role completely and do a lesser role, that can be considered a fundamental change in the employment contract and can be deemed a dismissal in and of itself. And it's treated as though the employee has been terminated from their employment.
So you're basically, just to like try to make this a little bit more layman terms, I guess, it's basically like you're almost forcing them out by changing their role to the point where it's unacceptable.
It's no longer what they had agreed to do when they signed that employment contract. It's not the same job that they signed up for,
right?
And it's worse,
right?
And in that case, it's basically a termination of their last of the position that they had.
Mm-hmm.
If an employee goes along with it and they're like, okay, I'm not happy, but I'll continue, I'll do this lesser job, then that can be seen as them accepting that role.
Right.
In those situations, again, this is specific to Ontario, the employee has to basically resign at that point. They have to say, okay, I'm not doing this. I consider this a dismissal, a termination of my employment, and I'm not doing it. And then there's typically a legal battle over what they are entitled to, because upon termination, an employee is entitled to different amounts of compensation. And if the role has changed so much that it's deemed a termination, but if it's a constructive dismissal, then they're entitled to compensation as though they've been terminated. Okay, so and that's if you are, again, if you're in a situation where you're injured and exactly that, you're struggling with your employer to find a solution and they just change your duties completely, including your compensation, that's when you need to start thinking about getting a lawyer involved, consulting with a lawyer, because a lot of people don't know this, right? They don't know what their rights are and what happens if those duties change. And there is an analysis that you have to consider, okay, how much did those duties change? Was it a pay decrease of $1 per hour, or was it a pay decrease of $10 an hour? And where's the line? And that's kind of where it's important to get a lawyer involved and at least, seek an opinion in those cases. So
here's another one here from the chat. If an employer wants to distinguish the injury as permanent versus temporary, I don't think the employer would distinguish that. I think it would be a medical personnel just says it's permanent versus temporary. Do they have the law applied differently? Do things change if now you're talking about a permanent disability?
Yeah, so that's a good question. So at some point, the contract can be deemed void, like it's where no one is required to live up to the terms of the contract. And if there's suggestion that an employee's incapacity or disability is permanent or otherwise shows no indication of allowing them to return to their job, then the contract is deemed void, and the employer they're not obligated to pay them out any termination. It's just the employment contract ends. But there has to be proof that this employee is never getting back to their job. That's called it's called frustration of contract. And it does happen. Like if someone has a physical job and let's say they get in an accident and they're just like, they become a quadriplegic or something like that, there's absolutely no prospect that person is going to get back to work. So in that situation, where there's three considerations, where the ability to perform the contract is radically changed. So in a quadriplegic, they cannot perform their duties. It's not the fault of either party, and that event is not adequately considered by the contract. In those circumstances, it's the contract's been frustrated, and you kind of just like wipe your hands clean and go your separate ways.
And in that situation, the person would be basically on just permanent disability.
Right. So yeah, and depending on your jurisdiction, depending where you are, there's different options available to people who do suffer injury and can't work. As I've already mentioned, a lot of employers do have short-term or long-term disability programs available to employees who do suffer, injury or any disability for that matter, that prevents them from being able to work. Typically, short-term disability is anywhere from, it lasts for a couple months and compensates the employee anywhere from 80 to 100% of their income. And then after those few months, long-term disability kicks in, and that's anywhere from around 60 to 80% of the income. So if an employee, if they're not returning to work, they can apply for those benefits. They can also in Ontario apply for employment insurance sickness benefits, which provides some income. They can apply for CPP disability. So if the worker is between 18 and 65 years old, they suffer a severe and prolonged disability, and they had contributed to CPP through their employment in 4 of the last 6 years leading up to the disability, they can get compensation that way. There's also ODSP, which is Ontario Disability Support Program, but in each jurisdiction, there are government benefits, or there sometimes are private benefits available to somebody, which they should seek out, because it's the employer's not going to pay them for the entire time that they're off.
Right. Now let's go back to the accommodation standpoint, right? Because I feel that a lot of patients are, kind of get screwed on this. Like I've seen it time and time again, where it's like this person wants to get back to work and the employer is basically saying all or none, right? You're either back full time or you're not. And if you can't make it back, then that's too bad. You can't come back until you're ready to come back. And so for us, especially as clinicians, trying to figure out a way to get this person back, there's certain professionals like occupational therapy that will actually kind of try to recreate the job, and have them, work at that to develop those skills and, get in a position where they can kind of jump right in. But a lot of times you have to be on the job. So if you have an employer that's not allowing for accommodations, like what's your recourse? Because a lot of people may not have a lawyer when they go into this, right? They may be just going through it and they're just fighting their own battle with, some jerk firm that's not allowing them to have these accommodations. What's the recourse? What should they do? How do they, how should they go about that?
Right. So they should go to their doctor, and they should get a doctor's note that they present to their employer. And if the employer is still saying, you have to come into work, we'll give you a week off, but you have to return to your full duties, full hours after that week, and you still present them with a doctor's note and they say they don't, too bad, then you just sit pretty, and your only option is to really, you can try to tough it out, but you're going against doctor's orders and you're probably making things worse. But you just you wait for them to terminate you, basically. And then your recourse is you can bring a claim against them for discrimination. You can claim under the Human Rights Code, or if they haven't met their obligations in termination pay, you could start a claim against them for that and bring in a human rights component. But you don't really have any you kind of leave it to your employer and hope that your employer is going to be acting in good faith and taking the medical documents into consideration. It's another thing, for your listeners who are clinicians, that they need to consider, reviewing the medical documentation and making their own analysis of how can we accommodate this person to the point of undue hardship, to the where we're not going to suffer too much financially or put others' safety at risk. It's a dangerous game for an employer to in the face of a doctor's note say, okay, you got to come back to work. a lot of times employers don't even have all the medical information. An employee's they don't have the employee's entire medical file. They're not necessarily entitled to know the employee's entire medical history. The doctor does know that. So if the doctor has that history and is writing this note, that they can't return to work, or they should be returning on a modified basis, then the employer should really they need to put some significant weight to that and try to accommodate as best they can. Otherwise, they face some legal repercussions for sure.
So what you're saying then, like prior to that, so if somebody, if you're not getting the accommodations you need and the employer is basically like all or none, and you're like, well, I can't do it, you have to sit there and wait till they terminate you before, like, you can't. What about going and getting legal representation to go and file a suit based on that? Like, some people can't afford to just sit around and wait to be terminated, because what if the employer is just like, I'm waiting for you to come back, like, let me know when you're ready, kind of thing.
When they're off, that's when they should be applying for those benefits that we talked about. If they do have the short term, because their employer is not going to pay them, but they should apply for those benefits if they think they're going to be off for a long time. And with their employer pressuring them, that should trigger to the employee that, this might not end well, and this might end in some litigation. And that's when they should really be focusing on documenting things to their medical providers and going to see whoever's treating them for their concussion. Like we said, a concussion is it's a very tricky injury. It's tricky for a few reasons. First is that it's invisible, like we've said. There's no way it's difficult to prove. It's not like it's going to come up on an X-ray, right? So you have to go by what the medical records show. And if it is going to get to the point of litigation, then those medical records are going to come out, and you're going to see how often, Johnny is complaining to his family doctor or his medical provider about his concussion symptoms. If he's going to his doctor every week, if Johnny sees his doctor on January 26, 2022, complaining of nausea while staring at a computer screen, his work requires him to look at a screen, and then on January 27th, his employer fires him because he refuses to look at a computer screen, then when it push comes to shove and you're going through the litigation, that's going to come out that, he was consistently, his condition was so bad that he was consistently going to his doctor and seeking treatment. And even despite that, his employer, cans him the next day. So those are things that employees should be doing if they see some sort of conflict on the horizon. You can contact a lawyer, but the lawyer is going to they're still employed until they're terminated, right? There's nothing to really do, until that termination happens, or until the change in their role happens, where they're constructively dismissed. And at that point, if they are terminated while on leave, then that's discrimination, because the employer has refused to accommodate to the point of undue hardship, and they've just terminated them.
What if they don't terminate them? What if they just say, we're not accommodating any accommodations you need? Like, that seems like if there's a duty to accommodate and they're not accommodating, to me, it's like, there should be something I can do to say, look, I need to try and get back here,
Yeah. I mean, I don't know that that's the employer. The accommodation would be the employer's letting them stay home, basically. Right. There is no, their disability is of such a severity that there is no accommodation to be made short of undue hardship. But there's still a prospect that it's going to get better, like I said, because if they're permanently disabled and there's no prospect that they're coming back, then that's a frustration of contract, and the employer has no duties or responsibilities. But if the employee is completely unable to work today, but their doctor's saying with therapy, whatever the therapy might be, things might improve over the next few months, then the employer has to accept that. They have to allow the person to stay home and recover, as long as allowing them to stay home and recover doesn't cause them undue hardship.
Mm-hmm. One issue, one big problem area that I see all the time is with teachers, because you have readily available people on the supply list to run and fill those roles when people are injured. And I think that, a proper protocol of getting a teacher back into the classroom would require them to go and, observe another teacher for an hour or two a day to kind of get used to the noises and the movement and the whatever, but not necessarily have that role. But for some reason, it's difficult for teachers to get those types of accommodations. So it's like they're stuck on the sidelines and not able to even go in and shadow. And those are one of the roles where it's like an all or none position, that it's like they'll just keep you sitting on the sidelines collecting disability, right? And it's like you're not allowing me the opportunity to do what I need to do to get back to where I need to get back to, because you're putting up a wall and not allowing it. So it's like, how am I going to get used to being in a classroom without being in a classroom?
So teachers unique. Teachers would fall. They're unionized. So in those circumstances, you'd have to go through your union and depending on the collective bargaining agreement, see what recourse you have. But yeah, like what you're saying is that, correct me if I'm wrong. So someone's got a concussion and their employer's preventing them from getting back to any aspect of their job.
It's basically all or none. Like if you're ready to take back over your classroom right now, like full 8-hour days, 5 days a week, then okay, let's go. But if you're like, no, I can only do 2 hours a day for the first 2 weeks, and then I can bump it to 3 hours per day. Like it's difficult for them, I can understand, to juggle schedules like that. One thing I've recommend is go in there and shadow the supply that's in there with you and just kind of help them out. So you have 2 teachers working one classroom for a few hours a day. You're getting back into it without having the full responsibility. So if you have an increase in symptoms, headaches kick up, dizziness kicks up throughout the day, you can duck out and not leave your class high and dry. And I mean, to me, that sounds reasonable, but whether or not, now who pays for that, where, you're paying 2 teachers to manage one classroom, and, I don't know.
It comes back to that duty to accommodate, like if they can't be treated, if the accommodation is to allow the person to, work a couple hours a day, and doing that won't cause them undue hardship, then the employer needs to make that accommodation. The employer would have to prove that by paying those 2 teachers a day, it would cause more than an insignificant amount of risk to safety or the board's financial stability, or it sounds ridiculous,
right?
It won't, but
yeah,
you take into consideration those different things when you're considering the undue hardship.
Right.
But that also, it makes me think of the other unique thing about concussions is that it's such a spectrum and a wide range of symptoms, right?
Mm-hmm.
Like you can be prevented from doing physical tasks as well as, tasks that require your mental capacity. Whereas other injuries aren't really like that. I have clients who do physical jobs and they get an accident and they break their leg. They can't go back to their job, but because they can't walk around or lift or whatever the case might be on their broken leg, but their employer says, "Well, you can go back to the office. Why don't you do a desk job until your leg heals up?" And that's typically okay. You can work at a desk with a broken leg in most cases. But with a concussion, it's like, not only is the concussion debilitating to your ability to do the physical aspects of your job, you're standing there with headaches and dizziness and nausea, whatever the case might be. But if your employer then goes and assigns you to a desk job, you can't do that either. You can't concentrate, you can't stare at a screen. So And I think teaching is a similar thing. Teaching is one of those jobs that, there's physical aspects, and you do obviously need your mental capacities. So it's a tricky, concussion is very difficult and stressful, and it's a tough injury to sustain, because it affects so many aspects of your life. There's there might not necessarily be relief. So that's why, depending on the job and depending on where you land on the spectrum of symptoms, especially with a concussion, it's important to be documenting those symptoms to your doctor, and then if you are unsure, find a lawyer, an employment lawyer or an injury lawyer, and see what your rights are, what your obligations are, and what you should be keeping an eye out for.
A lot of people are concerned about the costs that may be associated with that. Do employment lawyers, injury lawyers, do they typically allow for free consultations, or is that everyone's gonna be different, obviously, but what's the typical?
It depends. It really depends on the firm. I don't want to speak for other firms. I can say, with our firm, we do personal injury and employment law, and we typically work off a contingency, which means we're paid a percentage of any amount that we recover on your behalf, instead of being paid an hourly rate. That's how we operate. And I think typically personal injury firms operate on a contingency. I don't know about most employment firms, but we kind of use the same model in the employment disputes. But the personal injury and employment disputes, they kind of go hand in hand, because a lot of our clients, there'll be people who are injured in a car accident or a slip and fall, or whatever the case might be, and then they can't work, or they need accommodation at work, and their employer's not accommodating them, or their employer's telling them to come back to work and they can't go back to work, and their employer, they provide a doctor's note and the employer says, "I don't care, you're fired." Then that opens that whole can of worms of an employment dispute. So a lot of the times, these personal injury claims, unfortunately, come along with an employment claim. That's why we operate on a contingency basis. It kind of bled in our framework, our fee structure was with the personal injury. It was a contingency with the personal injury, but I don't know. I can't speak for other firms. I don't know what the norm is in other jurisdictions either.
So how early should you get a lawyer involved? Should it be waiting for termination, or should you, I guess as early as you see
you could,
fit,
as
right?
far as I'm concerned, you can call me if someone is injured and their ability to work is affected in any way, even if their employer is accommodating them. If a lawyer who does employment law is offering free consultations, give them a call.
Mm-hmm.
Even before the dispute arises, you'll be in a much better situation when it does get contentious, if you've already spoken to a lawyer and they're saying, and they've already advised you, you should be speaking to a doctor every 2 weeks or every month, or at least at a consistent basis, so that if it does get to that point, then you're prepared and you have all your ducks in a row. And I do that all the time. I'll speak with people. I'll kind of guide them, and I'll say, check up with me in a couple months. Let me know how it's going. And oftentimes it does get contentious because the employee can't work and the employer obviously needs them to work. So we're there when it gets to that point. So I would say, if a lawyer is advertising or puts on their website consultations are free, take advantage of it. They're not, they can't charge you if they're saying that. Give them a call.
Right.
And it's good for them, because it might turn into, you might be a client down the road.
Right.
They're happy to, at least we're happy to help. But yeah, I don't see a downside in speaking to a lawyer even before there is a dispute with your employer. You know, you want to be prepared.
Yeah,
For sure.
I would agree, because I think what happens a lot of times is people don't realize what kind of documentation they need, and then they're in a battle and they don't have the right ducks in a row, and they end up getting, you know, screwed over by it.
Yeah, or you even mentioned that situation where the guy's his role changed significantly.
Yeah.
You know, and like I said, if in Ontario, if you just go with that role change and then 6 months pass and then you think to yourself, oh wait, like, were they even allowed to do this 6 months ago? You're probably out of luck in terms of getting some sort of compensation or some sort of recourse for the employer changing your role. So if in the context of an injury, I think I would err on the side of speaking to a lawyer as soon as you can, even before you know, any conflict arises with your employer.
Anything else to add? I think we've covered a lot of ground there. Do you have anything else that you think we've missed, or?
Not that I can think of. I think we covered it all, but yeah, I would just say that if you are unsure of your rights, or if you're dealing with a concussion, you know, the physical and the psychological issues that come with that, and the uncertainty that comes with, you know, not being able to do your job, then speak to a lawyer and make sure you're speaking to your doctor or your medical provider, because all that's important. No one has a crystal ball and could foresee that, or no one wants to get in a dispute with their employer, but it does happen. You don't think it'll be you, but I see it all the time. But yeah, that's all I'd add. And just just thanks for the opportunity, Cam. It was fun, and I look forward to the next one for sure.
For sure. All right, everybody. That was Luis Quail. You can find him. You can send him an email at lquail, that's QUAIL, at qwklawyers.com. His office is 416-795-0683, and his website is qwklawyers.com. Your boy Dougie Licious here is messaging you. So
I'll give him a call. I can answer that question. All right, thanks, everybody.
All right, guys. Cheers.
Thank you.
Bye.